Hi, friends. Welcome to Immigration News by Ting Law. We have an important update for you. Yesterday, September 29th, 2020, Judge Jeffrey White out of the Northern District of California granted a preliminary injunction to block the fee increases issued by USCIS. They were supposed to take effect on October 2nd, 2020, this week. So a lot of attorneys and myself had been preparing and mailing out applications on behalf of our clients who needed to apply for something, and really, of course, encourage them to file as soon as possible. And now we just received this great news because, of course, there's many others who weren't able to provide the evidence in time. So what does this all mean? Number one, the judge had to verify in some way to see if there's the plaintiffs, who are a lot of nonprofit organizations. I believe there were 6 to 8 of them who filed this lawsuit against the Department of Homeland Security. But the judge had to review whether the plaintiffs would suffer irreparable harm and if there would be a likelihood of success if there was an actual final trial at that time, yesterday, for example. And so the judge did find both, that the plaintiffs likely would have found likelihood of success if there was a trial yesterday, based on the fact that essentially the final rule was in violation of the Homeland Security Act. Specifically, the judge said that the plaintiffs likely would have succeeded on the merits based on the information provided by the plaintiffs, and actually the lack of evidence provided by the defendants, which is Department of Homeland Security, that the acting secretary, Chad Wolf, and deputy secretary were unlawfully acting in those positions at the time that this rule was published. We'll explain more about this in a few minutes, but first I want to give you a little context why this fee increase is important in general. Number one, of course, no one wants to pay more fees. But, in general, I can understand if certain agencies need to increase fees for legitimate reason. Now, Department of Homeland Security did state that, based on their calculation, estimated that there'd be a 1.2 billion shortfall if they continue to receive the same amount of cases year after year. But we'll talk about that more in a few minutes in the case. But some new increases that would have happened is someone applying to become a U.S. citizen, naturalized to become a U.S. citizen based on an N-400 form. That fee right now is $725. That would have increased to about $1,100. So that is a significant increase, or $1,170. The second one is that someone applying to be a resident, permanent resident, or even a conditional resident, is that the form itself, 485, would have cost $1,140 right now. That's $1,140, which includes the form 485, the 765 form, which is for the work permit, and also for your 131. That is for your what we call advanced parole, basically your permission to travel. That $1,140 for those three. But what this new final rule would have done is to unbundle it. You think of your phone bill or your cable bill. They try to want to bundle it together. Well, this is unbundling. They're separating out the fees. Now, let me tell you what the final rule would have been. It would have been $1,130 just for the 485 form adjustment of status, $550 for the 765 work permit application, and then another $590 just for the advanced parole. So in total, that would have been $2,270. And I understand some of y'all in the audience are fans. I'm sure you would like to hire a lawyer, but it can be costly. I understand. So, and the government fees are already costly to most families that I know. So this is a very significant increase. I understand that. So I'm glad that all these nonprofits were able to file a lawsuit. But the third highlight I want to share with you is the $50 asylum application fee. That is a heinous fee in general, because for someone to apply for asylum, they're coming from a country where they're facing persecution, threatened, or actually suffer through persecution, suffer some kind of harm. So if they're coming to the United States, they shouldn't have to pay a fee at all to apply for asylum. Now, the rule is that you have to apply for asylum within 1 year. There's many other rules, but that's the main rule. Now, if you apply after the 1 year rule, 1 year of entry, there's something else. But there's been no fee up until this point. And there was going to be a fee of $50 starting October 2nd. And I understand for those on the conservative side, $50 should not sound much at all, but it's the principle. Someone is facing persecution, they shouldn't have to pay any kind of fee. If it starts, there's a sliding, slippery slope. If you start at $50, who knows, maybe in 5 years it could be $100. It's just going to increase. It's just like tax. It usually goes up. It might ebb down, go down a little bit, but essentially it's going to stay status quo in the same level. And also for people to apply for a work permit based on asylum filing, it's right now there's no fee, but it would have increased to from zero to $580 for someone who's filing for the first time. So that's an important note. There has been another rule that changed policy of waiting to 365 days of applying for your work permit. I haven't seen anything in the lawsuit. I read I think it was 30 pages of the lawsuit. It didn't mention anything specifically about reverting back to the 180 days of waiting to apply for a work permit after filing for the asylum application. So, but once we find out some information about that, we'll let you know about that, because I know many of our audience members or fans have been asking about that question. So please stay tuned. And if you haven't already, please hit subscribe down below and go ahead and hit the like button. That allows us to know if you like our content and enjoy how we prioritize the news, because there's so much going on. We just want to share the most important right now. Here's something else you should know is that the fee waiver criteria was going to change with this new final rule, the fee increase October 2nd. And what that was going to do was revert it from, for example, let me tell you what the criteria was before. And there was 3 criteria. Number 1, if you could show that you earn income less than 150% of the federal poverty guideline, that'd be number 1. Or you have to show that you receive a means test benefit, for example, some kind of supplemental nutritional benefit, like what we call AK, also known as food stamps. Or number 3, you could show some kind of extreme financial hardship. So regardless of with any of those 1, 2, 3 criteria, you have to show some kind of financial documentation, whether it's your income and also all your expenses. For our clients, we like to explain to a request, and especially if you have any loans, especially if you go like a place like a Title Shark or Title Max, or those type of places where they charge you high interest, any type of loan that's included, we want to add that into the fee waiver application. Now, the final rule was going to change it to 1 criteria. You have to show income. You have income less than 125% of the federal poverty guideline. So to give you an example, 125% of the federal poverty guideline is about $21,550, and that's a household size of 2. So that is the amount you have to show that you earn less than that in order to qualify for the fee waiver, if it was the final rule that was going to go in effect October 2nd. Now the current version is based on 150% of the federal poverty guideline. For the year 2020, it is, for a household size of 2, to give you an idea, is $25,860. So that's almost about 4,000 difference there. Now, I'll give you an idea of household size of 4 I don't know if this is a typical family size, but 125% of the federal poverty guideline, household size of 4 is $32,750. For 150%, it is $39,300. So that is about a 7,000 difference right there. So again, this fee waiver change in the final rule, it would have been a significant burden on families for sure. So it just it's a burden for people to pay these specific type of fees for applications if they can't meet this burden. I can imagine there's a lot of different family expenses and household expenses that are incurred, especially with the rising housing costs. I want to give a special shout out to our fan viewer named Singh. We appreciate your questions throughout the last couple of weeks. Now let's dive deeper into the case analysis of the temporary injunction that was just handed down yesterday. Now, here's a deep dive analysis of the case. We'll try to be as succinct and brief as possible. Number one, in terms of the likelihood of success on the merits as it relates to the violation of the Homeland Security Act, in terms of the order of the vacant succession, who takes over the top position. It's just kind of like how if the president goes down, then the vice president, and after vice president, it's the House Speaker. So similarly, the whoever is the current Secretary of Homeland Security, they can amend it. So what it was before was, number one, after the actual Secretary of Homeland Security is the Deputy Secretary of Homeland Security. Then after that person, if that seat is vacant, then it goes down to the Under Secretary of Management. And no one's in that seat, then it's the Commissioner of CBP. And that's what happened when Kristen Nielsen resigned in April 2019. The then Commissioner of CBP was Kevin McAleenan. We'll put his name right there for you so you can see it. I know I'm mispronouncing it. And then after that, Commissioner of CBP is supposed to be the Administrator of FEMA. Now, in November of 2019, Kevin McAleenan resigned. But before he resigned, he amended the order of succession. And so right before the Commissioner or Administrator of FEMA, he put in the position of Chad Wolf, who's now the acting secretary. I can't remember specifically. Oh, here it is. He's an undersecretary for strategy, policy, and plans above the FEMA administrator. So that's such a long title. I mean, at this point, it's just strange that President Trump is relying on this order of succession. It is at least 4 or 5 people down the line, and who knows how much goes to show how ridiculous it is that the President of the United States cannot find a reputable person who has experience with Homeland Security issues to lead the agency. And it's gotten 4 or 5 people down the line, and it had to be reordered so that Chad Wolf could even take over. Now specifically at the time that Acting Secretary Chad Wolf took over, position was vacant for already 217 days. That's a very long time. Now, the Homeland Security Act stated that the position cannot be vacant for more than 210 days without a confirmed secretary, beginning on the date the vacancy actually occurred. So at that time, it was April 2019 when Kristen Nielsen resigned. It was not when Kevin McAleenan took over, because he was never confirmed by the Senate. Or the second situation is once a first or second nomination for the office has been submitted to the Senate, which never occurred at all. So that's the first legal argument. The second legal argument, among many others, we're just going to go with these two, but the second one is that the final rule, the notice of proposed rulemaking process, was in violation of the APA, Administrative Procedures Act, stating that it was arbitrary and capricious, that DHS did not provide sufficient data or that we as a public could rely on in how the department actually came about to its specific fee increases. Sure, it can cite to its 1.2 billion shortfall that is still estimated, but how did it actually come to the inflation into the specific fee increases? Now, judge said is that the department failed to disclose the data, that relied on unexplained data, and ignored data in the record. The government actually provided a case related to the FCC versus Consumer Electronics, and how in that case, it worked in favor for the government agency, because that agency actually collected data throughout the years to justify its fee increase. But the Department of Homeland Security never continued to gather this data. So it cannot be, even though they used the case in its own favor, it backfired actually. In conclusion, the plaintiffs argued successfully and persuasively to the judge that this final rule of the fee increases has to be enjoined, basically immediately enjoined from continuing or starting on October 2nd, 2020, because specifically, in addition to what I mentioned, but that these fee increases would affect the vulnerable immigrant populations. And I want to also tell you about the scope. You've heard of past cases that said maybe it only affected that particular region of the country or that state. In this situation, the judge felt that it was warranted to be universal across the United States. So we'll see what happens from this case, the after effects of this case, and what data the government will actually provide. I'm excited to find out because I doubt that they have anything available. Friends, if you enjoyed the news today, please hit subscribe down below, share it with your friends, and also smash the like button for us. It lets us know if you really like our information that we provide, how we prioritize our news, and also please leave a comment below. Let us know if you've been able to file a case before October 2nd, or even if you needed more time. You appreciate that a lot of nonprofits have filed this lawsuit, because if you have, I understand that those nonprofits probably would appreciate any type of small donation to their cause. Until next time, please stay safe.